Hello and welcome to part 3 of Procopio's 6-part series on litigation and dispute resolution. My name is Ian Corey. I'm a counsel for Northrop Grumman and a board member of ACC's San Diego chapter. And it's my pleasure to thank Procopio for their sponsorship of our chapter and of this series, and to introduce today's session and speakers. So after 2 previous sessions on managing litigation and key litigation trends, today's session will focus on internal investigations and related matters like whistleblowers. And today's speakers are Gina Miller, who's a Procopio partner. She represents employers in a wide range of labor and employment matters, offering both litigation defense and proactive counseling. She has extensive experience defending clients in federal and state courts, as well as before administrative agencies such as the Labor Commissioner and the Equal Employment Opportunity Commission. In addition to her litigation work, Gina advises employers on key employment policies and practices, including drafting and updating employee handbooks, arbitration agreements, employee contracts, wage and hour compliance, vacation policies, and managing leave of absence. And she's very familiar with internal investigations. Thank goodness for us. And the other speaker is yours truly. Again, I'm Ian Corey, a counsel for Northrop Grumman's Networked Information Solutions Division, which is headquartered here in San Diego. I support business units that provide communications, secure processing, and cyber solutions as both a prime contractor and a major subcontractor, primarily for U.S. government programs. And before joining Northrop Grumman, I served as a lawyer in the U.S. Army JAG Corps. Now, if you have any questions during today's session, and we hope you do, please put them in the chat. And all right, Gina, would you please get us started?
Absolutely. Thank you so much, Ian, and thank you to the ACC. It's great to be here today. This is a topic that's near and dear to my heart because, as a litigator, I'm frequently get the investigations that's been done internally, and sometimes they're done well, sometimes they're not done so well. I also, do a fair of my own investigations. So they're really important. And so I'm going to kick us off. Let's see. Okay. So first off, what are investigations? I mean, what kind of opportunity does it provide for the company? The biggest thing is risk mitigation by far. You have an opportunity to, get these individuals in a room, do your investigation, and try and resolve a dispute before it turns into, somebody getting an attorney and everything costing, everything quadrupling in terms of cost. So you have an opportunity to advise and correct the behavior. You can improve employee morale, because we all know that there's interactions that, might not always bubble up to the surface, but it kind of gives you an understanding of what is going on and, how to improve employee morale. Also just demonstrating how important the company's policies are. And it gives you sort of a pre-litigation opportunity to get all the documents and evidence and testimony. So, and then one of the most important things is you lock witnesses in to what their allegations are, usually long before an attorney has an opportunity to come in and add, 4 more layers of allegations into it. So they're really important. Like I said, I've seen companies do them really well. And then I've seen other companies, not do them so well. So here are the types of claims that can require an investigation. I mean, any sort of discrimination, harassment, retaliation, of course, under California law, those are most likely going to trigger a duty by the employer to investigate. A lot of times they use those buzz terms. So you really have to look at what is the actual complaint, what is the wrongful conduct being alleged. But if you see discrimination, harassment, retaliation, those words, typically that means there needs to be an investigation. Also health and safety, workplace violence or threats, drugs or alcohol, violation of the employment policies, theft or fraud, any other criminal activity typically is going to require an investigation. Your goals in the investigation is, is everyone safe? Did someone violate a policy? You want to be thorough, you want to be impartial, and you want to, you want to expedite the investigation. You don't want to wait a month, and I was thinking about this today, just if I put my corporate counsel hat on, and I've never been an inside, in-house counsel, but I can imagine the deadlines and the things that you've got to get back to your client. And then somebody comes up with a complaint and you don't really have the bandwidth to put that into your daily tasks at that time, because maybe something is pressing to get it done, a contract reviewed. But I can't tell you how important it is to, take the time and do the investigation. Don't wait a long period of time. You may miss the opportunity to do it because the employee may quit the next day. So I would be sensitive to that. Your goal is not to catch someone in a lie. It's not to trick or embarrass a witness or succeed in getting somebody terminated. So we're going to talk a little bit about why you should conduct a workplace investigation. There's obviously legal requirements, but also there's this other thing called what is your corporate culture? Again, it might not be something that rises to needing to do something for legal reasons, but it might be a good opportunity for, somebody to intervene and prevent a conflict from bubbling up to being something more, so, and it's a great time to set, what is the expectation of the corporate culture? We want this place to be a place people want to work at. And so if you have disputes, even if they don't bubble up to something, that requires an investigation, it's a great opportunity to, figure out how people can be happier at work, what's going on. If you have somebody that, it might not be, harassment or discrimination or something like that, but it could just be somebody that's yelling at somebody or talking, cutting them off, or, things like that, where you can counsel that to, improve the discourse at the company. So the legal requirements, because Procopio is based in San Diego, I'm going to talk a little bit about California law, but we'll get into the federal. And, under California law, this Cotran v. Rollins case is a really important case under California law because, this involved a supervisor who had been terminated for good cause. And the California Supreme Court, was looking at what is the role of the jury, in deciding whether this was a proper termination. Is the role to see if the company had good cause to terminate? Or is the role to see if the company acted in good faith and reasonably believed they had a good reason to terminate this individual? So, that's a great case for employers, because you don't have to prove that you had good cause to terminate. It's a nuance. All you have to prove three things, and they laid it out in this case. The employer has to show that the employer acted in good faith, that they had an appropriate investigation, and there was reasonable grounds for believing that the employee had engaged in misconduct. So what this means is the jury could have said, I don't necessarily agree with the employer's ultimate conclusion that there was misconduct here, but their process showed that they acted appropriately, they acted in good faith, and they had a reasonable basis for how they came out, So it's an important case. And then the Silva case came along, and the Silva case is a great case for employers because that case said, I'm going to dismiss this case on a motion for summary judgment. And the Silva case was also a sexual harassment case. It involved a store manager who had been accused of sexual harassment by two women. And the employer was obviously the defendant in this case, and the employee was taking the position that they didn't have for cause termination. And the employer filed a motion for summary judgment and said, we've met all three factors as a matter of law. You don't even have to go to a jury trial. We've met all three factors from the Cotran case, and there doesn't need to be a jury trial. And so, and this case is really good for going through what is a good investigation. You know, is it timely? Do you have a good investigator? Is it unbiased? You know, in this particular case, within a month of the complaint happening, 15 employees had been interviewed and a conclusion had been reached that the store manager had violated sexual harassment policies and he was terminated. And so, you know, the court found this was a really thorough investigation. It was done internally by somebody at the company. And, you know, he investigated everybody. These witnesses, you know, had their statements there, and the company acted reasonably. The investigation was made in good faith. And we think that the company had reasonable grounds to conclude that this guy, you know, that there was for cause for termination. So that's a great case for employers because, you know, it's a tough standard, but you know, it is out there and you know, kind of tells you exactly how to do an investigation. So the EEOC, you know, that their view of what constitutes a proper harassment investigation: prompt, fair, impartial, confidential to the extent you can, you know, keep it confidential, thorough, you know, there's good training at the company on the issue, you know, proper questioning, determining credibility is good, making a determination, all of those things. That's what their view is of a proper harassment investigation. Other legal obligations. So under federal law, you have the Burlington Industries and Farragher affirmative defenses. These are really important cases because what these cases found is under Title VII, this was originally in a sexual harassment case, but what these cases found is that it's an important legal shield for an employer to have a viable complaint procedure. So if there's a sexual harassment complaint, you need to have a procedure. I'm sure all of you do in your employee handbook. And if the complainant didn't utilize that procedure, never told the company, hey, I was sexually harassed, that is a complete defense in sexual harassment cases. And it's been interpreted since these cases came out to actually expand to other harassment cases, such as those based on race, religion, or other protected characteristics. So that's a great, you know, legal defense. Now under California, you know, we got to do things a little bit differently here. It's not a complete defense, but you can use your complaint procedure as it's called an avoidable consequence doctrine to limit damages. And the concept is that we had a policy in place to prevent sexual, you know, harassment. You didn't utilize it. And therefore, if you had any damages flowing from this, they should be offset by the fact that you didn't utilize our procedure. So those are kind of the legal foundations of why you really want to take, you know, having a complaint procedure and, you know, using it. There are some really practical ways they can help you in a harassment or a discrimination, you know, claim down the line. So what is a good investigation? You know, you want to have a policy about what your complaint procedure is, and you want to follow that policy. And if you depart from it, you want to have good reasons for departing from it. So you start with a good policy. You want to look at, you know, a trained professional assigned to address the complaint and the accused. You want to interview all the relevant witnesses, and you want to make sure you get all of the key documents so that, you know, a document is suddenly is missing or somebody deletes a text. You want to make sure you gather all that information. And then, you know, you want to have appropriate corrective action, and then the results of the investigation are communicated to the complainant. So that's a good investigation. Here's just an overview, taking the complaint, very, very important stage, because in my mind, that starts the framework of what the investigation is, and hopefully it limits the framework too. So that if later down somebody sues, you said, oh, well, you didn't make a complaint about this. These are the two things you complained about. This was the wrongful conduct. So that's really important. Then you have a planning investigation stage, conducting the investigation, making a decision, and documenting the investigation. So, okay, so this just kind of goes a little bit different way. You want to document the complaint, evaluate whether there are any preliminary issues that need to be considered. You want to determine whether there are any documents that you need to be reviewed or preserved. Important issue, determine whether to conduct the investigation in-house or hire an outside investigator. And we'll talk about this a little bit later. You want to develop an investigation plan. You know, who do I want to interview first? What order? You know, conduct the witness interviews, properly document the investigation, and then recommend final steps. Okay, so step one is a critical one, because you received the complaint, written or oral. And a lot of companies have 1-800 numbers, or, it's go to your manager, go to your supervisor, or if they're not available, go to the HR director. It's important in your policy to always point out that they have more than one person, in case, the person, who they're complaining about is their manager. So you need to have HR, their manager, maybe a 1-800 number. You want to have, take notes of what the complainant describes as the issue, basic questions: who, what, when, where, how, what witnesses were there. This is just kind of an intake. What are the relevant documents, emails, texts, notes to file? Ask the complainant to commit the complaint to writing. And I would really, I get a little nervous about that, because a lot of times they put a lot of buzzwords in there. I feel sexually harassed because of X, Y, and Z. So, but it is nice to have their actual writing, like, hey, this is, and it, you can ask them some questions, even if you have them do, a form that they fill out that says, list, the wrongful conduct that you're complaining about. Like, we really want to focus on the wrongful conduct. We don't want to call this conduct discrimination. We don't want to call this conduct bullying. We want to know a chronological review of the facts. We don't want opinions. We don't want conclusions. We want, and I'm going to say that a lot throughout this presentation, but I just say that because, frequently I get these investigations and I'm like, oh man, I gotta put this in front of a jury, and they're going to assume this is sexual harassment. It's not sexual harassment, but they're calling it that. So, but I do think it's powerful to see what they're complaining about. 1, 2, and 3. What is the wrongful conduct? And then later, when they try and expand upon that, that's, you have documentation to say, oh, well, one day after it happened, you said just these 3 things, and now you're saying 10 things. So, yeah, so that's, kind of the importance of getting a complaint. It also, really sets, go ahead.
Sorry, I was just going to say, there are also situations where we get anonymous complaints, and unless there's just no actual information, like the who and the what, for you to look into, you still have a duty to make at least some kind of a good faith inquiry into what may have happened.
Definitely. So, step 2 is evaluate whether there are any preliminary issues. And this is really, you look at the complaint and you're kind of thinking, okay, what am I dealing with here? Am I dealing with an isolated incident? Am I dealing with teasing? Am I dealing with criminal behavior? Am I dealing with the CEO of a public company, these are, you kind of, once you get the complaint in and you look at the severity of the wrongful conduct that's involved, you start to look at, okay, should we get law enforcement involved? What is our legal duty right here? Should the accused employee be suspended or transferred pending the investigation? I kind of like the paid leave of absence option. That's probably my biggest go-to, I would say. If I feel like there can't be, if it's so severe that I don't feel like they can continue to work together at this point, I like the paid leave of absence. But, you have to look at all of these things through the lens of, well, is the accused going to sue us for wrongful termination, or is the complainant going to sue us? So that's the way I'm thinking about it. But it really depends on how severe the conduct is. Is there a supervisory relationship here that needs to be modified? With that, you need to be really careful about, putting the complaining party in a situation where they're not, you've moved them or something like that without their consent, or they're in a situation where they're not where they want to be. I would be hesitant to do that. So these are complicated issues, and it really depends, on the context and who's involved, how severe the allegations are. Should you have a law firm retain the investigator so the investigation is privileged? If you have a situation with a higher up at a public company, I think you seriously want to consider an investigator that's retained through the law firm, because you can maintain privilege, and then you can waive the privilege if a lawsuit ensues. And assuming you're in arbitration and you have arbitration agreements, there's a way to kind of keep some of this confidential. You might have to disclose that the company did a reasonable investigation. So at some point, you might want to waive that. I can see doing that later down the line. But, at the beginning, I think if you have a pretty severe allegations involving a higher up, I usually, there's some pros and cons, but I usually like, having your law firm retain an outside investigator. Step 3, are there documents that need to be reviewed and preserved? These are good to get before you go into the actual interviews, but there's obviously personnel files and time cards and medical files, email and voicemail and videotapes and internet searches. It could involve social media. You want to have that stuff gathered before you start your interviews to the extent you can. Step 4, should I conduct an investigation in-house or hire an outside investigator? Outside investigators, one note I should say is that under California law, there's very specific individuals that can do investigations. So of course, California law has rules on this. It can be a private investigator. It can be an attorney who is practicing, as an attorney, like a licensed attorney, not an attorney that is practicing as a doctor, or something else, but an attorney that has some experience in this area. It also can be an employee of the company. Under federal law, there's not a lot of rules centering around what you have to have, but I did see on the EEOC's website, you need somebody who's trained, ideally in sexual harassment, who's done investigations before. They like to see, okay, this person, has experience in doing this. One of the benefits of having an outside expert or outside investigator is they have experience in testifying. So you have to make some, kind of judgment calls that at the beginning to kind of figure out, and you don't know if it's going to end up in litigation or not, but I think you know from who's involved in the complaint and the severity of the wrongful conduct, whether there's a good chance it could end up in litigation. So internal investigators, they're obviously cheaper. They have a lot of credibility with the employees. They are oftentimes, they're familiar with your corporate culture, what's said all the time internally, what's important, what's, the personalities and the policies. And I would say internal investigators, they're gonna probably stay a little closer to the scope of the investigation. I've had some experiences with outside investigators where they, you tell them like, this is, we envision the scope of it being this, just interview this person, and maybe one or two, and they come back to you and they say, oh no, we want to go, and we feel like we need to, so you have a little less control with an outside investigator for sure. But at the same time, it also looks, more independent because the person, isn't employed by the company. They're not getting a paycheck from the company. So that's the benefit of having an outside investigator. So yeah, you have increased objectivity, lot of great experience. A lot of times they've been a practicing attorney for a long time. You want to develop, step 5 is develop an investigation plan. And you want to, it's just like kind of similar. It's very similar to litigation in the sense that you want to go, okay, who you might not know right at the beginning, but based on the intake form, you might be able to see, okay, these are the potential witnesses. What documents would I really need beforehand? Because what if this person says this? What are the orders of the witnesses? Usually it's kind of natural to start with the complainant. I think that's typically where I can't think of a time when I haven't started there. So, and then I move on to, other witnesses, and then maybe I go to the accused at the end. So I kind of get an understanding of what the, other witnesses have to say. So, this is just your opportunity to kind of create your plan and get an understanding. It's good to have you never know what's going to happen in these interviews. And it is really good to be armed with the company policies, know those policies, have them in hand. If you need to understand, if there's been prior complaints, that's in their personnel file, or they've been written up for other things, it's good to just be, obviously, in most things in life, it's good to be prepared. So
Gina?
then you conduct the witness interviews. It's good to have a second company representative present. That hasn't happened in all of my investigations for sure, but it's obviously good because there could be he said, she said, or she said, depending on, if your attorney's male or female. But you want to review the purpose of the interview with the witness. You want to address retaliation at the very beginning. There's going to be no retaliation. You want to ask non-leading, non-judgmental cases, stick to who, what, when, where, how. You ask, is there anything else? Do you have any documentation that supports this? This is not a cross-examination. This is trying to get their story and understand, what the wrongful conduct is, who was present, what documents support it. And so here's a couple of issues that may arise. I just had this actually a couple weeks ago. I had somebody that said, I need my attorney here. And I mean, that's very rare that somebody will say that, but it does come up, periodically. It's an internal investigation. The way I deal with that is, I try and say, listen, ordinarily we don't have attorneys. This is not, a legal process. It's an internal, company investigation. But if you want your attorney here, he or she can be here, but they're not going to be able to talk. So, they can be present, but they're not going to be able to talk. So, I would say that very rarely happens where an attorney it actually comes to an investigation, but it has happened. So, so there are some cases under California law here that, basically support the concept where a company, the employees have to be cooperative in internal investigations, and they can be terminated for not being cooperative. And California has a labor code statute that just talks about, employees having to follow the directives of the employer, and cooperating with the company. So you can have an issue with confidentiality in these witness interviews. The way I do it is I explain that I can't promise complete confidentiality, but I say that as to the extent possible, we keep the interview as confidential as possible. And so, a lot of the integrity of your investigation depends on witnesses not talking to one another and saying, well, I told investigator X, Y, and Z, what are you going to tell them? And so, the question becomes, can you have these witnesses sign confidentiality agreements? So, so this Banner case, it doesn't really address investigations or confidentiality clauses in the context of an investigation, but it talks about the National Labor Relations Board, which, for those of you that don't know, the NLRB is a federal agency that, has their own, administrative law judges that can go out and file claims against companies for violating employees, rights. And I think traditionally their biggest concern is Section 7, which allows employees to meet and gather and talk about their wages and picket if they want to. And so they're very sensitive. The NLRB is very sensitive, obviously, to confidentiality provisions, because if you can't talk to your coworkers about, your wages and unfair labor practices, how are you going to ever join a union or picket or do any of those things? So they want to protect employees' ability to speak to one another about their wages and about the working environment and those sorts of things. And so, I think if you have, a legal basis to show why confidentiality is so important, protecting witnesses, from, further, physical attack or abuse or anything, avoiding spoliation of evidence, avoiding fabrication of testimony, preventing a cover-up. I think you have to show those things as a basis. Usually what I do in my interviews is I say, I want to protect the integrity of this investigation, so I would appreciate if you keep what we talk about in here confidential. And then I explain that I cannot be completely confidential from what I hear. Obviously there could be some things that I have to, if there's, law enforcement, I'm going to have to go to law enforcement, but that's kind of how I deal with it in these interviews.
Hey, Gina.
Uh-huh.
Before we move on from interviews, just a reminder that if attorneys are conducting the interview, we need to give the witness an upjohn warning, which is just the name of a Supreme Court case. Some people call it the corporate Miranda, where basically you're telling the interviewee, hey, I represent the company, I don't represent you in your personal capacity.
Yes, absolutely. Yeah, very important piece of if you're an attorney and you're interviewing them, you have to give them that upjohn warning. Okay, so I just want to check on time. Okay, so step 7, this is properly document the investigation. Of course, as an outside litigator, this is so important because, we get the investigation. Your objective is to, get a really clear, concise documentation of what the allegations are. Delineate them. There's 4 allegations here. You want to document the scope of the investigation, the policies and procedures at play, the relevant facts, documents received and reviewed, witnesses interviewed. You want to avoid any opinions, rumors, legalese. You really want to give concrete examples. And again, this is just stick to the facts. Refer to documents, include dates, times, and witnesses as applicable. You don't want to include subjective information, legal conclusions, matters or issues that are not relevant. You're not an advocate. You don't want this to be looked at as, advocacy. You want this document to show impartiality. And yes, you reach some conclusions at the end, but, this is not, a brief where you're advocating for a certain conclusion. So you want to have a tone of impartiality. So here's an example. You want to make some findings. You want to have the allegations listed 1, 2, 3, 4 at the top of the report, and then, a short conclusions with reasons. We conclude that this allegation occurred essentially as employee Smith alleged. Supervisor Doe admits he made physical contact, including an attempted kiss. Co-employees Richard and Sedgwick each provided separate and consistent accounts. So that's one way you can, have a finding. You could also have something that says, we conclude that this incident probably did not occur, and the reason why you conclude it likely didn't occur. And this allegation says, we are unable to determine with reasonable certainty that this event occurred as alleged. There were no witnesses except for the parties themselves, no corroborating evidence of any kind. So you definitely want to have a section where you make some findings. So you want to recommend discipline if that's appropriate. This is step 8. You want to communicate the outcome to the complaining party and the accused. And that can be tough. I must admit, sometimes you have to call somebody up and say, our findings, we concluded this was an isolated incident and this person, this was teasing, and the comment, the way they intended the comment, you have to kind of tell the person that this isn't really as severe as you think it is. And so, and they don't like that, right? So, that can be a difficult conversation, and there can be, things that come out after that, where they are bubbling over in anger because they don't like the way the investigation concluded. But it is really important that you make a conclusion based on your findings, and you communicate that. And, you think about, is there anything, could a policy be stronger? Do I need to continue to monitor the situation? And then report to the government if it's appropriate. So those are kind of the final steps. What are the 10 common mistakes that an investigator makes? I would say, ignoring complaints would be the top one. Everyone's busy, right? And these come out of nowhere. And sometimes they're really severe complaints, and they need to be addressed right away. And failing to prepare and plan, get all the documents in place. You never know what's going to come out in those interviews. And so the better you can prepare, the better those interviews are going to go. Losing objectivity, that definitely can happen. Being overly aggressive and again, sort of losing the idea that we want to show we were impartial. This was an impartial investigation. It was a blank slate, even though the investigator may work at the company, they came at this really as a blank slate, and they didn't come at this with a preconceived notion of how it was going to turn out. So, and then ensuring your corporate culture is maintained. I think you should be thinking about after the investigation, do you want to follow up? Because obviously somebody's upset about how the investigation turned out, and um, if you say you're going to follow up with somebody, um, you should follow up with them afterwards, so I'll check in with you after this, kind of is over. Because sometimes I've noticed sometimes if there's a lawsuit later comes out, they said they were going to check in with me, they never came back. I've seen those types of allegations. So again, there's definitely a risk management here, but there's also this is our company culture. We want to try and maintain a good working environment where people want to go to work every day, but there are going to be disputes, there are going to be conflicts, they are going to result, usually in favor of somebody and not in favor of somebody else. And so you want to try and mediate and kind of make sure that the corporate culture is the way you want your company to be is really maintained even after the investigation. So Ian, I believe, is up next.
Yeah, well, thank you very much, Gina. That was a great rundown of how to properly conduct internal investigations and a lot of the pitfalls to avoid, and we've seen a lot of them. So now we're going to pivot to whistleblowers, and if you go to the next slide, please. All right, so some of the employees who make complaints could be characterized as internal whistleblowers, if you will. And what you really want to avoid is for those employees to eventually become external whistleblowers. And you do that by addressing their concerns in-house. So I'd like to frame this at the outset with a few statistics, which I thought were surprising. Maybe you will too. According to a 2021 report from the SEC whistleblower program, over 75% of whistleblowers to the SEC received an award for the information that they provided, had reported their concerns internally before they went to the SEC. And there's also some pretty interesting research and some findings that were reported in the Harvard Business Review that essentially demonstrated that companies that experienced more internal reporting or more internal whistleblowing actually did better along several metrics. They experienced fewer lawsuits, and the lawsuits that they experienced tended to result in smaller settlements and fines, comparatively speaking. And it seems kind of counterintuitive, doesn't it? So why would that be? Because we tend to think that companies that have a lot of reports must have a lot of problems. But this research suggests that actually the opposite is true. So even though some issues could be corrected that come to light in a company, what this research demonstrates is that if you're not getting the internal reports, it may actually be a sign that your internal processes, your internal communications, maybe your culture are broken, rather than a sign that you're doing everything well. And so conversely, more reporting may mean that you actually have better communications, that you have something that at Northrop Grumman, at least, we like to call a speak up culture, such that the company is really in a better position to address the issues that arise. Next slide. So what helps to improve that communication? Really, it's an effective internal reporting program, like Gina mentioned, because whistleblowers really are, in effect, a risk assessment tool. Does that mean that every complaint is going to have merits? Well, of course not. We've seen a lot of complaints that lack merit. I'm sure you've seen many, many, Gina. But often we hear whistleblowers characterized as, oh, it's a disgruntled employee, or they're reporting for an ulterior motive. And that may often be true. But I think that you're being short-sighted if you simply write them off and deny yourself, deny the company an opportunity to investigate, and if necessary, address the complaints internally before they potentially become a bigger problem, before you now have an external whistleblower. So it's important, as you heard Gina discuss, to encourage that internal reporting and to have a clear process that ensures that employees know who they can go to with their concerns. And also, importantly, that when they do go to those people with their concerns, that the supervisors or whoever they contact, whether it's the law department, HR, business conduct advisor, whatever you have, to ensure that whoever they contact is supportive and, again, reflects a speak up culture. And it's critical that those complaints are then thoroughly investigated, following those steps that Gina laid out and walked us through. So again, this is an opportunity. Why was this concern raised? Is it a one-off? Is there a systemic issue that we need to address? And the investigation should point to whether there's actually something that needs to be remedied or not. And whether the investigation concludes and whether the company actually takes action or not is as Gina noted, crucial. Regardless of what happens, it's crucial to have a dialogue with the employee who voiced a concern to explain if the company is taking action or not. You don't have to get into the details, right? They don't need to know, well, this is what we did to the employee that you reported about, but they need to know that something happened, that their complaint was taken seriously and investigated thoroughly. It's also important that a company be willing to basically demonstrate a willingness to change, maybe an openness to modifying its systems or its processes. We often hear people say, well, that's the way we've always done it. And that's not always the right answer. Is the company a learning organization? Does the culture embrace doing the right thing? That willingness to change helps to ensure that reporting continues, because otherwise, really, what's the point? And it's kind of like the cautionary tale of the lawyer who always says no. You know, if you always say no, eventually your clients stop coming to you for advice. And of course, the law prohibits retaliation. So that should be clear within the company's policies and within its culture. Next slide. All right, so we can also see a fairly consistent pattern or set of patterns in what's called qui tam litigation. And qui tam litigation is one of the ways that the Federal False Claims Act tries to combat fraud against the US government. And basically it allows whistleblowers to file a lawsuit on behalf of the government. And if the suit is successful and leads to a recovery, the whistleblower, who in this context is called a relator, is entitled to a percentage of the recovery. Not a bad deal, right? And that recovery is based on whether the government chooses to intervene. Basically, if the relator would recover 30% if the government chooses not to intervene, and the relator has to basically go it alone. Otherwise, they'll get less if the government intervenes and basically takes over the case. So the pattern that we tend to see in this type of litigation is that a whistleblower raises a concern internally. And remember that statistic from the SEC that 75%, or actually more than 75%, of those folks have raised their concerns internally first. Then they feel that their concerns aren't being taken seriously or addressed appropriately. Then they often are terminated or they quit. And then finally, they become that external whistleblower that we want to avoid and file a qui tam lawsuit. So one of the takeaways is that if effective internal reprograms resulted in whistleblowers feeling heard, that wouldn't necessarily have made the problem itself go away, but it might have reduced some of the company's cost and exposure. And then I threw a little infographic on the right. I plugged the settlement from the DOJ website. It resolved both civil and criminal charges back in 2012. And I plugged this one in particular because at over $3 billion, it's the largest ever, as far as I know. It's still the largest ever. But don't be fooled by the age. You know, it's from 2020 or 2012, but there have been many recent ones since then. You can find them on the DOJ website. And in fact, in fiscal year 2024, settlements and judgment under the False Claims Act exceeded $2.9 billion. Now, that's less than that $3 billion settlement from 2012, which is really pretty impressive. But nonetheless, whistleblowers also filed 979 key town lawsuits in 2024, which is a record number. So the threat is there and continues. Next slide, please. So shifting gears a little bit, DOJ's criminal division also rolled out a corporate whistleblower awards program last year that focuses on 4 subject matter experts that are listed here. And it's essentially meant to fill in the gaps that weren't covered by existing whistleblower programs, like the one that the SEC has. And here again, whistleblowers are eligible to receive 30% of any civil or criminal forfeiture that the government collects as a result of that complaint. Now, interestingly, DOJ says that this new program actually promotes companies' internal reporting programs. How so? Well, DOJ says, well, one factor is that we can increase the amount of the whistleblower award if the whistleblower actually reported internally and assisted in any internal investigation. And conversely, we can decrease the whistleblower's award if they knowingly took actions that undermined a company's internal investigation. So I don't know that companies are necessarily thrilled that their internal reporting programs are being quote unquote promoted in this fashion, but it is what it is. Next slide. All right, so the whistleblower awards program is also supposed to complement the Department of Justice's voluntary self-disclosure program. And under this program, companies can voluntarily choose to self-report issues through the voice of a company, as opposed to those issues being reported through the voice of a whistleblower. And here, basically, if a company reports an issue to the Department of Justice within 120 days after a whistleblower reports the issue to the company can receive a presumption of prosecutorial declination. And when this program was first rolled out, there were a couple of additional criteria for that presumption of declination. A company had to voluntarily self-report the information first before the department learned about the conduct from a source other than the whistleblower, and before the department reached out to the company for information. So that kind of put companies in a difficult position, because if they get an internal whistleblower complaint, they only have 120 days to investigate it and then figure out what happened and then figure out what they want to do and then report to the government. And that's really not a whole lot of time. And that time could have been arbitrarily reduced if the department had reached out to the company in the interim. But last month, the department relaxed this a bit so that now if a whistleblower makes both an internal report to the company and a submission to the Department of Justice, the company will still qualify for that presumption of declination, even if the whistleblower goes to the department before the company self-discloses, as long as the company still reports within 120 days after receiving that internal report and meets the company's meets the policy's other requirements for voluntary self-disclosure. Next slide, please. So real quickly, how are a few ways that the companies can minimize that risk of internal whistleblower becoming an external whistleblower? Well, have we mentioned the need to have an effective internal reporting program? Yeah, I think we have. So a couple of other things to consider. How well trained are your managers? Your managers are typically your first line of defense, or maybe they're a weak link in the chain, right? Because most, if not all, or many, if not all, complaints are made directly to managers or first line supervisors. Are they properly trained on how to address those concerns? Remember, Gina mentioned that one of the top investigation mistakes is ignoring complaints. Well, do managers just kind of blow off the complaints, or do they act in a way that indicates that the company takes these things seriously? Do the managers support a speak up culture? So consider whether managers need some training. Also, a lot of companies reward employees for good ideas that can save the company money or result in something that's more efficient. What about incentivizing employees for coming forward with concerns, right? If employees are motivated, truly motivated by money, they may be motivated to report externally anyway, because you heard about the types of recoveries that they can share in. But these kind of incentives might help reinforce a company's commitment to ethics and compliance. And then finally, Gina and I discuss the importance of closing the loop with the reporting employee once the investigation has concluded. So an additional step might be that the company might just kind of broadly broadcast kind of what it has done. For example, at Northrop Grumman, once a quarter, there's an infographic that shows how many reports were received in the previous quarter, the percentage that were anonymous, and as a side note, the fewer anonymous complaints there are, that's considered to be an indicator that employees feel more comfortable about speaking openly without the fear of retaliation. It also shows the percentage of reports that were substantiated. It shows the top 3 categories of allegations and also the top 3 forms of corrective actions, and also reminds employees of those different reporting channels that are available to them. All right, we're running out of time, so next slide, please. Real quickly on government inquiries. We're in the home stretch here. I'll preface this by saying that hopefully there is some thought put into how a company will respond to various types of inquiries before they occur, or at least identifying the right people to reach out to if an inquiry does show up. Because, for example, if law enforcement shows up with a search warrant, that could be your receptionist. Does the receptionist know to call counsel? All right, so the first thing is figure out what's the nature of the inquiry. What are they asking for? What are they really trying to get at? Are they asking for information about the company, about an employee, maybe about another company? One of my programs received a subpoena a few years ago, and of course, the pucker factor went up and a lot of red flags were raised. But really, after talking to the assistant U.S. attorney, it turned out that the government was trying to build a case against one of our suppliers, and we were considered a victim. Or is it something that seems like a routine request, but really it's something that could turn into a law enforcement action? You also want to consider whether you want to hire outside counsel or can handle it in-house. Sometimes it's absolutely appropriate to handle things in-house. But sometimes if the company is facing legal exposure, for example, you probably want to consult outside counsel. What about record production? If the government directs you to produce documents, don't play games. Unless there's a claim of privilege, you need to provide the responsive documents. You also need to act quickly to issue a litigation hold or a preservation notice and instructs employees not to dispose of or destroy or delete those documents until further notice. Companies also typically have protocols to automatically delete emails from inboxes after a certain amount of time or for periodic document destruction. You have to suspend those pending resolution, right? And then finally, you want to document everything. You want to document who you spoke to, your interactions with the government, your internal investigation, your communications with outside counsel. But you want to be careful what you put in writing too, right? Because sometimes things can get blurry as to, well, that's covered by a privilege, or no, actually that's business advice that's not covered by a privilege. And keep in mind the old 60 Minutes test. Would it be okay if what I put in writing ultimately became public? If not, maybe don't put it in writing. So that's a very brief discussion of government inquiries. And back over to you, Gina, for a closing. You're muted, Gina. You're muted, Gina.
Sorry, guys. Thank you so much. We're right at 101, so we're going to sign off. If you have any questions, here's my email address. Feel free to email me or Ian if you have any questions. But thank you for being here today.